Copyright is probably the most widely encountered form of intellectual property, and it's important to understand where that comes from and how it works, and also important to understand what can be protected by copyright and what cannot. So copyright is a property right created by the law of a country that grants the creator of an original work exclusive rights to its use and distribution within that country. Now, in this definition here, I've used the word country twice, but I just want to emphasize that despite various harmonizing directives in Europe, and despite many international treaties, copyright is still very much a national affair. It's still very much a country by country affair. And so the law can vary quite a bit from one country to another. And also the scope of any copyright law applies only within the jurisdiction of that state. Works can be books or film or music, sound recordings, lots more. There's quite a lot of flexibility in terms of what can be protected by copyright. And as technology and culture has evolved, the scope of protection has been expanded to cover these new kinds of things. At its most basic, copyright law prevents others from making copies, selling copies, or exploiting the works. So if something is protected by copyright, you can't make a copy of it. A good example is a book. So the author of a book owns the copyright in that book. The author can then give a book publisher the right to print copies of that book and sell them. So that's a deal then between the author and the publisher. Anyone who prints books without the permission of the author is breaking the law. The author could also give a film company, for example, the right to make a movie based on the book. So copyright can be very well understood in relation to books. When it comes to other things, for example, computer programs, it gets a bit trickier. And of course, copyright was initially devised in order to protect books. So it's no coincidence that it's a good fit for books. There are two different justifications for copyright. There are two different ideological, philosophical, and legal traditions that are being drawn on. The first justification is the instrumental justification. And this argues that providing an incentive to authors to create new works will increase the number of works in circulation. So if we give someone an incentive to write books, then as a society, we will have more books, we will have access to material. People can afford to take time off to write books, and as a society, we'll all be better off. There's a second tradition then, which draws on the author's rights, or droit d'auteur in French. And this is the idea that a person has the right to control their creations. And so we have copyright because when someone writes a book, it's an extension of their personality. It comes from their creativity. And we as a society should protect their right to have control over their creations. So that's focused on the individual. And these two traditions often give rise to some of the differences in opinion on what should be protectable and what should not to be. It's fair to say that in the English law tradition, that is in much of the English-speaking world, it's primarily the instrumental justification that is used. And then in continental Europe, there's more of a droit d'auteur tradition. Copyright was considered so important that it was written into the US Constitution in 1787. And if we look at the text here of Article 1, Section 8, Clause 8, do you think it's drawing on instrumental rights, instrumental justification, or on author's rights? It says to promote the progress of science and useful arts. So clearly here the purpose is the advancement of science and the arts, the benefits that copyright and patents, in this case, would bring to society. It's about the benefits to society. Interestingly, Ireland lays claim to the oldest recorded copyright dispute. So St. Columba studied under St. Finian, and he borrowed a manuscript from Finian and secretly copied it. It was a psalter, a prayer book. And Finian objected to this and demanded that Columba hand over the copy that he had made. They took the matter to the king, and he is reported to have said, "To every cow its calf, and to every book its copy." And so in Ireland we claim anyway that this is the oldest known copyright case. If I understand correctly, it was even a factor in a war. More recently, however, we consider modern copyright law to have its origins in the Statute of Anne in 1710. And this law provided copyright for authors, and there was a copyright term of 14 years with one optional renewal available. And then once that term expired, the works were in the public domain, which meant that anyone was free to use them and anyone was free to copy them, anyone was free to exploit them after that period of time. So an author had 14 or 28 years during which to make his money from his book, after which time anybody could have it. We'll see later that that initial period of 14 years has been extended and extended over the years by many years, and it's arguable that it's now at a period that is not reasonable anymore. So the most important question then is, what can be protected by copyright? There was a case in 1916 where the judge said, what is worth copying is worth protecting, which seems a fairly broad definition. In 2000, another judge criticised this, saying, this maxim is open to the criticism that it proves too much. So it is possible that entirely mechanical labour may be saved by copying something produced by entirely mechanical labour involving no skill. And this raises the question, is mere copying of something, without any creative input, does that constitute something that is itself protectable? This is a question that has come up. The real question really is, what's the threshold of creativity that's required? In the 1800s, there was an international convention that afforded authors from different countries protection abroad. So before the Berne Convention, for example, an English author could only protect his books in England. And the Berne Convention gave people rights outside of their home country. It defined literary and artistic works to include all sorts of things, and you can read this list here. So even in the 1800s, the definition of literary and artistic works that were protected by copyright was actually quite expansive and quite broad. So books have been protected since at least 1710, but the interpretation of literary works is very liberal. and lots of types of works would fit under that category. So we've had cases with advertising slogans, rail timetables, a shopping list even, which seems like a stretch to me. Exam papers are protected by copyright. And very importantly, the quality of the work is not a factor. So the law is not interested in deciding if something is good enough to be protected by copyright. It has no interest in the quality of the work. So in a case in 1900 here, Walter v. Lane, the judge said that the right, in my view, is given by the statute to the first producer of the book, whether that book be wise or foolish, accurate or inaccurate, of literary merit or of no merit whatever. So the law has no interest in considering the quality of the work. So a massive range of things then can be protected by copyright. Obviously books, film, when film came along, was protected, musical compositions, sound recordings. So there can be copyright in a song, but there can also be copyright in the recording of someone singing that song. And that recording is its own separate copyright. Sculpture, photographs was an interesting one. Drawings, engravings, we don't see much of engravings anymore. Plays, computer programs, an important one, a new one. Typographical arrangements, so the style of a magazine, for example, the choice of font for the headlines, for the body of the text, the layout of the magazine. So independent of the content, independently of the words used, the layout itself can be protectable. In computer science, we might consider this to mean that the style sheet itself is protected separately from the content. And databases are also protected by copyright under certain circumstances. I mentioned earlier that copyright is primarily a national affair, and so we're going to look at the copyright law in Ireland. If you're in the UK, the law in the UK would be the relevant one. If you're in France, the law in France would be the relevant one. So in Ireland, it's the Copyright and Related Acts 2000. And it says that copyright subsists in original literary, dramatic, musical or artistic works, sound recordings, films, broadcasts or cable programs, the typographical arrangement of public editions, and original databases. An important word here is subsists. So copyright subsists in a work as soon as it's created and put in tangible form. And by subsists, it means you don't have to do anything. It's just there. Some works may be too trivial to be protected by copyright. So names, trademarks and titles are not considered literary works, and so they're not protected. Something like Opportunity Knocks, for example, a title of a TV show, was not protectable. So something may be too trivial to be worthy of protection, but that's not to say it's not of good or bad quality. It's not a qualitative assessment. Importantly, computer programs are protected by copyright. There was a lot of debate about this over many years, but it's settled now. People felt, and I guess they were people that didn't write computer programs, that computer programs were purely functional things and that the code necessarily stemmed from the function, and so there was no creative element there, and so that meant computer programs should not be protected by copyright. But it's very clear to anyone who writes code that there's a lot of creativity in there, and the law is anyway settled now. Computer programs are protected by copyright. Importantly, the works created in the preparation of writing the code, like the analysis and the design documents, they're also covered as literary works. So it means, for example, that if someone had prepared analysis and design documents and requirements documents and then eventually wrote the code in C, for example, someone couldn't steal all the preparatory work and then write the code in Python, for example. So the documents that are produced leading up to the development of the work are in themselves protected by copyright. As I mentioned earlier, the typographical arrangement of a work can be protected by copyright separately from the content. So the style of a work can be protected. So if you bring out a new edition of Sherlock Holmes, even though Sherlock Holmes is out of copyright, the creative choices that have been made in terms of the typography, the layout and the style and the formatting, all of that can be protected independently of the actual novel. Databases are a tricky one because we have the idea of an original database and an unoriginal database. So it is possible that the design of a database has been sufficiently creative and original that the database design itself is something that's protectable by copyright. It may also be that the contents of the database are original, and so then the overall database is original also. However, there is a scenario in which the database design is fairly humdrum and is not a creative work in of itself, and also that the contents of the database may be mere facts that are not in themselves independently worthy of copyright, and so therefore as a collection could not be independently worthy of copyright. And in Europe we have a special kind of protection for databases that are not original, and that's a database right. So you can protect a non-original database from being duplicated or exploited under certain circumstances. That's separate from copyright. So when it comes to protecting a database by copyright, we have to ask, is the database itself original or not? If it's original, it can be protected by copyright. If it's not original, it might be protectable under the database right under certain circumstances. So there are two criteria then that are required for a work to be protected. It must be recorded in tangible form and it must be original. I mentioned earlier that copyright subsists, so you don't have to do anything special to copyright a work. So the work is protected as soon as it's fixed in tangible form. It must be in tangible form for good reason, really, because, the law has no business protecting things that are in your head. So if you have an idea for a novel in your head, well, what are the benefits to society of protecting that if it's only in your head? If you're not going to write it down and share it with the world, then we get nothing from it. So why, as a society, should we protect the idea in your head? Why, as a society, should we stop someone else who's prepared to actually write the novel from putting that idea down and sharing it with society if you're not going to do that. A poem recited in public but not written down might not be protected by copyright, for example, because again, if you take the instrumental view of copyright, like what is it we as a society do we get out of that in exchange for that protection? There's nothing in society, there's nothing for society in that deal. Now the law is very flexible as to the form of the tangibility, so even if it's an electronic form, that's considered tangible. Originality then is the tricky thing. What's original and what's not? What's original enough then that we would protect it using copyright? And of course, originality is different from quality. If you see a movie, you might say, well, that's not a very original movie, or that's not a very original novel. But we're not talking about originality in that sense. There we're using originality almost as a synonym for quality. But copyright is not interested in the quality of the work, only whether it's new and original. In general, the threshold for originality is very, very low, and often it means little more than just not copied outright. It's important to remember that the work doesn't have to be, good, it doesn't have to be fantastic, it doesn't have to be unique. In English law, the old test was there labour, skill, or judgment involved? And there were some interesting cases that can highlight the threshold. There was a case in 1964 where it was ruled that original means only that the work should not be copied, but should originate from the author. So if it wasn't copied from someone else, it's original, which is a very, very low threshold in fairness. So labour, skill or judgment was the test that was typically applied in English law. And there's very little required from the author in that situation. And it has its roots in the instrumental justification for copyright, where we want to protect someone's investment in producing the work so that as a society we can get more works. So the author was almost considered, an investor, a person put labour, put effort into something. And so then as a society we should protect that effort, protect that labour, protect that investment, so as a result we can have more works in circulation. But it was all about the author's effort, labour, skill or judgment. In various cases down through the years there's been variations on that. So in 1923 we had knowledge, labour, judgment or literary skill or taste. In 1964 we had work or skill or expense. So the investment there, work, expense, they were talking about effort. And in 1986 we had skill and labour. So again there's the effort expended by the creator in the production of the work. There's a very interesting case from 1900 which highlights some of the difficulties with this approach. So Lord Rosebury was quite the orator in his day, it seems, and his speeches were very popular. And a reporter transcribed some speeches of his, and these were published in the Times newspaper. Now, in 1899, a book of his speeches was published, and it used text copied from the Times. So someone published a book of the speeches that had been put in the newspaper. Okay? Now, it wasn't Lord Rosebury who was publishing the book. He had no part in this, actually. This was done without him at all. But the reporter who published the speeches in the newspaper felt that his copyright had been infringed. And the House of Lords agreed with him. The House of Lords rules that there was copyright in the speeches because of the effort required to transcribe them and add punctuation, for example. So Lord Rosebury was making the speech, the reporter was taking down what he was saying, typing it up and putting it in the newspaper, and that effort on the part of the reporter was considered worth protecting. And that effort was considered enough to have there be copyright in the finished product. I think perhaps today we might not agree with this approach. So in the case, it was said that it is a great hardship if protection is not given to reports of speeches which can only be produced by the expenditure of much time, money and toil. So you see here there was no talk about creativity or originality. It was time, money and toil, the effort put in by the reporter. I very much regret the conclusion that the state of the law permitted one man to make profit and to appropriate to himself the labour, skill and capital of another. Capital there, investment. So copyright law was very focused on the effort that someone put into producing something, and that no one then should be able to just reap the benefits of that effort freely. If we go then, 90 years nearly ahead, mere copying of existing works doesn't really cut it anymore. So if you put a lot of effort into copying something, does that mean then that the new copy is worthy of copyright? Well, no. So in this case, which involved Lego trying to stop the production of copycat Lego bricks, not ones containing the trademark Lego now, but just things that functioned as Legos but didn't contain the brand. And this case rested on drawings for Lego bricks, and the argument was being made that the producers of these Lego bricks had copied the design drawings of the Lego. Now, there was never any actual evidence of that, but the point was that the case rested on whether new drawings of the Lego bricks, the design drawings for the Lego bricks, which had been copied from older ones, whether there was new copyright in the new drawings, which were in essence just copies of the old drawings but had been redrawn. And the court ruled that skill, labour and judgment merely in the process of copying cannot confer originality. So if you put a lot of effort into copying something that's already there, we're not going to give you copyright in that new copy just because it was a lot of work. Whereas in 1900 we saw that actually the effort alone was the determining factor. Photographs then, of course, are another obvious example of this. Taking a photograph requires a lot of labour and skill and judgment and often, significant investment. So if you're a photographer and you go flying around the world, it costs you a lot of money to take those pictures, and so you shouldn't have that work, exploited without your consent. No one should be able to reap the benefits of your efforts, of your investment. So if there's money to be made from those pictures, someone shouldn't be able to just copy them. And that makes sense for certain kinds of photographs. But what about then photographs of existing works? So this has come up in situations where, let's say, someone goes into a museum and buys a postcard with the Mona Lisa on it, brings that home and scans it and puts it up on the web. Does the person who took the photograph of the Mona Lisa have copyright in that photograph. And you're kind of saying, well, it does take a bit of effort. It does take a bit of time to go and take a picture of the Mona Lisa. But by the same token, Leonardo da Vinci is long dead. The copyright on his work has expired. We'll look at the copyright terms later. But whether it's 14 years or longer, he's long dead. So how can the Mona Lisa be still protected by copyright? And so it has actually come down then to whether the work is like a 2-dimensional or 3-dimensional work that's being photographed. So if a photograph is of a 2-dimensional object that's intended to be a perfect copy, so a photograph of the Mona Lisa should look as close to the original as possible. That's what the photographer isn't trying to do. Then that's not really worthy of copyright. Whereas if there's a 3-dimensional sculpture and someone goes and takes a photograph of that sculpture, well, that photograph of the 3-dimensional work does involve some creative decisions. It also obviously involves labour, but it involves something of the photographer. It involves creative choices in, say, positioning the object or positioning the camera, choosing the lighting, all these things. So in that situation, we would consider the photograph to be worthy of copyright. But effort expended in making a perfect copy of something that already exists isn't worthy of copyright. And rightly so, because then sure nothing could ever leave the copyright term, because you could just keep making copies of it. And those new copies would be protected. That's useless. So that was the labour, skill, judgment, investment, capital type test for whether something should be protected by copyright or not. And that's the traditional English test. And that predominates in the English-speaking world. In continental Europe, then, we have a different test where the question is how much of the author is in the work. So if the purpose of copyright comes from the author's rights, from the droit d'auteur, if it comes from the work being an extension of the author's personality and a creative impulse that's connected to the author, and we want to protect that, well then the question becomes how much of the author is in the work. So this intellectual creation test draws on the author's rights justification, and we see this coming up in French law and in German law under different guises. So when it came to photographs, for example, and the question of whether a photograph should be protected or not, in this directive here, the European law made it clear that a photograph was original if the author's own intellectual creation was in there. So if the photograph is the author's own intellectual creation reflecting his personality, then that's enough for it to be protected by copyright. The same was applied then to a computer program in a different directive. And it was a computer program should be protected if it is original in the sense that it is the author's own intellectual creation. And we saw the same when it came to databases, if the database was the author's own intellectual creation. So for photographs, computer programs and databases, it isn't about labour, skill, judgment, effort, investment. It's about the author's own intellectual creation. Now we could ask what that means, but that's the test. We could ask, is this a completely new test? Like, is the labour, skill and judgment test gone for good and been replaced by the author's own intellectual creation test? Or is it that photographs, computer programs and databases were special cases anyway, that were always going to be problematic? It's probably the case that these were hard cases anyway, and so maybe that clarification was needed. But it is worth bearing in mind that there are two traditions informing what's considered original: the English law tradition and the continental law tradition. The instrumental justification, which says we have copyright for the benefit of society, and the droit d'auteur, author's rights justification, which says people should have control of their creative works. And we see in some of the law, there's different things then that come from each of those different traditions. The final law that we have draws on both of them. A very, very important thing that must be considered in copyright law is the idea-expression dichotomy. So I mentioned earlier that copyright law does not protect ideas. If you have a great idea for something, you have no protection for it until such a time as you put that in tangible form. So if you have a great idea for a song, in your head it's no good. You must write it down or you must record it. If you have a great idea for a novel, in your head it's no good. You must write it down or put it in tangible form. So in Ireland, for example, the law is very specific, and it says that copyright protection shall not extend to the ideas and principles which underlie any element of a work. So we don't protect the idea, we only protect the expression. So there are situations then where the issue is at the idea expression boundary and there's not total clarity. So this image here is from a company that produced tourist products, I suppose. I was going to use a less kind word. Products for tourists. And this here, obviously, as you can see, is a famous London bus in red against a monochrome picture of the Houses of Parliament. And this was used by Temple Island Collections for various products, tea towels, biscuit tins, that sort of thing. A company then, New English Teas, wanted to sell tea, and if I understand correctly, it even approached Temple Island Collections in order to license this image and say, can we, use that in our products and we'll pay you whatever. And they said no. So New English Teas went off then and said, well, look, I suppose if you don't want to license that, we'll go make our own. So they went away and they made a separate image which has a red bus against monochrome Houses of Parliament. So I think we could all agree that they copied the idea for the picture. But it's also a matter of fact that not a single pixel was copied. Like nothing was actually copied. They went away and got their own picture of the Houses of Parliament. They went away and got their own picture of the bus. And if I understand correctly, the bus was photoshopped in actually. It wasn't on the bridge. It was separate, photoshopped in, and then, with the various colours and whatnot. An easy enough job to do in Photoshop. So the idea was copied, but not the actual image. Nevertheless, Temple Island Collections sued New English Teas and won, which was quite shocking. Here also, this involved fabric, and the House of Lords found that the fabrics here, the fabric here on the left was copied. in the production of the one on the right. Now, I think certainly there's maybe an idea there that you could say is shared, but it's hard to imagine how one could consider one of these a copy of the other. So these two cases illustrate the difficulty in determining the distinction between the idea and the expression. I'm not a judge. For my money, in both of these cases, the wrong decision was made. But they illustrate the difficulty there between separating the idea and the expression. But as a general rule, the idea is not protected, only the expression. So two people could have two independent expressions of the same idea without anybody infringing anyone's copyright. So far, we've spent quite a bit of time considering what can be protected by copyright. Let's ask the question now, if the work is protected by copyright, what rights does that give the author then? So what can you do with your copyright, or what can you stop being done with the copyright? And we'll look at Irish law here just as an expression of that. In some respects, the law is very similar throughout different countries. You could even argue it's an example of an idea, an expression. We're going to look at the expression of these ideas as they come out in Irish law. So the owner of a copyright in a work has the exclusive right to undertake or authorize others to undertake all or any of the following acts. So copy the work, make the work available to the public, and make an adaptation of the work. So the most important one there is copy the work. So if you own the copyright in a book, you can authorize others to make copies.
It's 12 hours.
So if someone else does copying, well then they're infringing the copyright and breaking the law. Creators of work also have moral rights. And so here we see even the law in Ireland drawing on the droit d'auteur tradition. So these moral rights are concerned with more than just the economic aspects of copyright. If you are an author, you have some rights over how the work is going to be used. So the paternity right is the right to be acknowledged as the author of the work. So if you write a book, even if you sell the rights to the book to a publishing house, or you assign the copyright outright to someone else, notwithstanding those economic concerns, you have the right to be identified as the author of the work. So you can see how that actually has nothing to do with money really, and just to do with the work being an extension of the individual. The integrity right is the right of the author to have his work remain intact and unadulterated. So this is something that film directors often complain about, in that they produce a work and then the work may be edited for television and get chopped up and have, ad breaks at inappropriate times, or the movie could be re-edited without their permission. And so this is similar to the integrity right. So if you are the creator of a work, you have the right to object to any distortion, mutilation, or other modification of it. What seems like a fairly simple question in relation to the copyright in a book can be more complicated for other kinds of works. So, depending then on the type of work, the author is considered to be whoever. So in the case of a sound recording, it's the producer of the recording. In the case of the film, it's the producer and the director. In the case of a typographical arrangement, it would be the publisher. In the case of a computer-generated work, it's the person by whom the arrangements necessary for the creation of the work were undertaken. This is a very interesting one, actually, because there's a lot of talk at the moment about if a work is generated by an artificial intelligence. Does the artificial intelligence own the copyright? Now, first of all, it's kind of a silly question, I think, because an artificial intelligence can't own any kind of property. I mean, you can't sell a house to an artificial intelligence. So I don't know how an artificial intelligence could own another kind of property. So in my view, it's a bit of a red herring, but it's a question that comes up. Now, in Ireland, it's very simple, actually. We have this thought through already. And if it's a computer-generated work, then the person who set that all up. And you could see, of course, how if you're coming from the labour, skill, judgment, effort, investment, capital approach to copyright, well, then like the person who paid for the computer and paid for the electricity and, paid the programmers and set the whole thing up should own the copyright. You can see, however, if your view of copyright comes from the author's own intellectual creation tradition, you might find it hard to accept that anyone other than the artificial intelligence created the work. You might find it hard to accept that there was no individual human input there to make it worthy of ownership. Similarly then, in the case of an original database, the individual or group of individuals who made the database, and in the case of a photograph, the photographer. So if a person takes a photograph, they own the copyright in the photo. This can be interesting where there's a model or a celebrity, or when you pay someone to take confirmation pictures, you're shocked to learn then that they own the copyright in the pictures, This strange question then came up when a chap didn't quite lose his camera, but his camera was taken by monkeys, and this monkey managed to take a photograph. And this monkey selfie case was quite celebrated and broke the interweb there for a while. And the question here was, who was the owner of this photograph? Who held the copyright in the picture? A group of animal rights activists in the US tried to make sure that the monkey owned the copyright in the picture rather than the person who owned the camera. But they didn't get very far with that. It was ruled that animals can't hold copyright, that only humans or corporations can. In Ireland, we would probably say, well, the person, we could probably interpret the camera as being a computer, which in some respects they are these days. And we could probably draw on that notion to say that this was a computer-generated work. And so the person who made the arrangements for it to be taken, that is the photographer, was the owner of the copyright. So again, this was rather a silly case, but it did raise some questions around ownership and the requirement for the human intervention and the human activity in the creation of a work for copyright, as opposed to the mere investment of time and effort. The issue has also come up with Anne Frank's Diaries. So the copyright in Anne Frank's diary expired 70 years after her death. Now, we know a lot about Anne Frank's life thanks to her writings. And we also know she met a very sad end. And we can pinpoint that tragic ending to her young life to a very specific year. So we're quite clear when she died. But 70 years after her death, when the work was due to come into the public domain because the copyright had expired, her father claimed that he had actually edited the work and so was in fact a co-author of the work. And therefore the work didn't enter the public domain until 70 years after his death. And this was quite controversial because for many years Anne Frank's diary was presented to the world as a first-hand, unadulterated account of her experiences. But then to be told many years later, well, actually, no, it is a work that had two authors. That was quite unsatisfactory for some people. And of course, we know Anne Frank's father died long after she did. So that would put the work in copyright protection for many years longer. Which brings us then, of course, to the duration of the copyright and how long it lasts for. And this is a not uncontroversial issue. We saw that in 1710 you got copyright for 14 years, but you could renew it for another 14. Now it's pretty much about 70 years, depending on the work, but it's pretty much 70 years after the death of the author. So for a literary, dramatic, musical or artistic work, or an original database, which I get a hoot out of that one, the copyright expires 70 years after the death of the author. Now we've seen that the instrumental justification for copyright is that it incentivizes authors to produce works, and therefore we have more works in circulation, and as a society we're better off for that. But some people would argue it's very hard to incentivize dead people. And should a work still be protected 69 years after the person who wrote it is dead? Now, one argument is that it would be very unfortunate if I was to write an absolutely fantastic novel, having spent 5 years of my life working really, really hard on it, 5 years during which my family hardly ever saw me, but I knew it would be worth it. I knew it would be worth it in the end because it was a great novel. And then the day after I published it, I fell under a bus. There is an argument that, it would be very harsh, and that an author's family and an author's kids even should maybe get some benefit of the work even after the person is dead. Notwithstanding the fact that once I'm dead, you're not going to incentivize me to write any more, but I suppose the knowledge that I would be able to provide for my family after my death might have been part of the calculation I would have used to decide whether to spend all that time writing the novel or not. So then the question is, how many years should that be? Should it be 20 years after a person's death, 50 years, 70? It was 50 in many places for a long time, but now it's pretty much 70 everywhere. And there's certainly an argument that 70 years is too long. So that's the main issue with copyright. The copyright lasts until 70 years after the author's death. Now, there are special cases then, and we can look at some of those, but they're really just tidying up. So if someone has a pseudonym and you don't know who actually wrote the book, then, there's an issue there, for example. The copyright in a computer-generated work expires 70 years after the date on which the work was first lawfully made available to the public. So if it's computer-generated, then 70 years after that, okay, so it doesn't really matter when the person who made the arrangements for it died. So that's a little bit shorter, but still 70 years is a long time. The next thing we need to look at then is there are some exemptions to copyright. So an absolute ban on copying creative works would be a bit restrictive. So there are some exemptions that have been carved out, but they're quite limited, and they're really, in a commercial context, they're not terribly useful actually. They're not get out of jail free cards. So the Berne Convention from the 1800s does allow for states to provide exemptions, provided they do not conflict with a normal exploitation of the work and do not unreasonably prejudice the legitimate interests of the author. So there are some of these in Ireland. We had to bring in law, for example, to make it legal for people to tape things on the television. So we don't see so much of this actually, but there was a time you had a video cassette recorder and you could record your episode of Fair City if you weren't going to make it home on time, and then you could watch it later. Technically, in the absence of an exemption, in the absence of something making that lawful, that would have been a crime. That would have been a breach of copyright because you were copying a television program. And so we had an exemption in the law to allow that. This obviously then also applies to recording something to a hard disk if it's being aired live. But of course it doesn't allow you to copy movies and distribute them and stuff. So there are a few quite narrow exemptions then for copyright. There's education, there's libraries, and there's public administration. So in education, you can, if it's for research or private study, you can copy some works, provided that you don't go overboard. And if you're reviewing something or if you're criticizing something, you can copy parts of it or make a copy of it without infringing the copyright. Also then, in terms of education and higher education, for example, someone can make a single copy of a work without infringing the copyright if it's for instruction or preparation for instruction. So this allows school teachers to copy something from a book. It allows lecturers to copy an article, for example. In the US, there's a somewhat broader provision that's called fair use. And fair use, of course, isn't actually of any use to you if you're in Ireland. But if you are publishing something in the US, we often see this on YouTube where people are quite explicit about their using the fair use provision to do what they're doing. And you can claim fair use under certain circumstances. So depending on the purpose of the character of the use, the nature of the copyrighted work, the amount of the work that's been copied, and the effect of the use on the potential market. So if you are making a YouTube video and you're using someone's song, well, that could harm the market for that song, because someone could just play your YouTube video instead of buying the song, or instead of streaming the song from the musician's channel, or instead of streaming it on Spotify. So that might not be considered fair use then. Parody is often used as a justification for fair use. What I found very interesting in the Irish legislation was it was very, very clear that decompilation of computer programs did not constitute fair dealing. So if you take someone's machine code, there are programs you can use that can analyze that and can reproduce a higher level language version of that code that then could be analyzed. Converting a computer program in a low-level language into a version expressed in a higher-level language is not fair dealing. So that's not allowed under the copyright exemptions. So I thought that was a particularly interesting one for anyone who does computer science. And making computer program backups is allowed. So if you have a computer program and you make a copy of that program, under normal circumstances that would be infringing the copyright. But if you're doing that for the purpose of a backup, then that's okay. I also found it very interesting that it is possible to use other people's code in order to figure out how you can write code that works interoperably with it. So let's say you want to make a program that works with another program. Well, you can copy that other program and you can do things that might otherwise be unlawful in the process of figuring out how to make it interoperable. So I think a lot of thought has actually gone into the legislation in Ireland. They have considered quite a few unusual cases that perhaps only us computer scientists would ever have worried about. So in summary then, copyright is probably the most accessible and most important and most widely encountered form of intellectual property. And the types of works that are protected are very, very broad. So photographs, computer programs, even databases under certain circumstances. The threshold of originality is quite low. So my shopping list that I write when I'm off to Lidl or wherever, that's protected by copyright. You might say it's not especially creative, not especially useful, it's not valuable. None of those things apply. So there's no qualitative threshold. It's just, is it original or not? And the threshold is very low. Registration is not required. So copyright subsists as soon as you put the work in tangible form. It's protected by copyright, even if it's only in your cupboard. In practice, however, copyright is required. Registration is required in the US, really, in practice. Technically it's not, but in practice it is. But outside of the US, it's not required. And very importantly, just because something is on the internet doesn't mean it's free to use. So if you find a photograph on the internet, you can't say, oh, well, it was on the web, so I just took it. That's an infringement of copyright. If you find text on the web and you copy and paste that and you put it on your website, that's an infringement of copyright. You might say the text wasn't particularly original. Not a defense. So if a work is protected by copyright, only the author can give permission to produce copies of that.